3 days ago, my original video titled "2Mad's Biggest Hater Jameski is a Liar" was removed for violating YouTube's TOS. My appeal was rejected within minutes for confirming that the violation was real, as well as my reaction to Turkey Tom's live stream of the video that he created, which was also temporarily removed before Tom could re-upload it. Gokunaro got hit with the same clip, the same TOS violation, as well as lyrics confirming that the 5-minute clip, or however long people included in their content, violated YouTube's TOS. This 100% confirms that Jameski is a liar because he said the audio files that 2Mad provided were fake, which now we know they were 100% real. Enjoy the video. I want to apologize to all the 2Mad fans for my delay who was looking for my response to Jameski's 52-page Trust Me Bro manifesto against 2Mad. Part of my delay was I wanted to make sure I had every exact document that I needed from the courts, and I was missing 4. And you're probably wondering like what those 4 court documents is. I wanted to make sure I had all of the court transcripts of everything that was said every time the counsels and respondents, which is 2Mad and petitioner Goldilocks, met in front of a judge. And today we are going to get into all of that. I'm going to show you how to request these court documents so you don't have to take my word for it. I'm going to show you how to request the court transcripts because you don't need to take my word for that either. You can get the court documents yourself. Nothing is sealed. Everything is open to the public, and we're about to get into it.
No. Wait.
Now, when 2Mad passed away, his death was pretty much heard around the world, but there was one person who couldn't wait till he died to defame him. That's right, that's Jameski, former friend turned obsessive ex-girlfriend, if you will, where he made these allegations that 2Mad tried to kill him. Despite his 52 pages, we saw no clear evidence of that, and the fact that he was alleged a PDF file. Now, when it comes to the PDF file, I think that's been debunked pretty good. Compliments of Misty, who has come out forward and basically said, hey, I'm the 13-year-old, now 14, but whatever. But I'm here to say that 2Mad was not a pedo, nor did he groom me. I have been locked in a psych ward for the past few months and only very recently got out. This is why I haven't said anything. 2Mad never made any appropriate advances towards any time during our friendship. He was a close friend to me, and his death has hit me really hard. Please stop referring to me as evidence that he was a pedo. I honestly don't know about the attempted deletion or the grape stuff, so I won't comment on that due to the fact that I've been the main reason that 2Mad has been labeled a pedo. I feel that I should address this. Jameski is lying about me. Well, you know, this was called out by some other people to say, hey, you know, how can this be verified? You know, Jameski's going around saying text messages are fake and he has a book style disproving it. Well, this person did a screen record showing that, hey, this is indeed a real response. But, you know, people who hate 2Mad are going to believe other things. Now, look, guys, before we start, I am not here to defend 2Mad's drug use or harassment. We know he did that, and that's basically what's mostly comprised of Jameski's 52-page manifesto. But before we get into that, there were some things that Jameski said, okay, that needs to be addressed, if you will, especially about the reason why it took so long to solve the case. What did he say? There was never a lawsuit at any point. Okay, yeah. Sure. We will address that for sure. But most importantly, what he said was the fact that it took time, right? It took many jurisdictions to make this stick. The main reason it took so long, being investigated by multiple jurisdictions in states, and the amount of everything they had to do that go through has been insane. I'm telling you, this guy is really the Mama Max, if you will, of basically anything regarding 2Mad. The problem is when anything that goes across state lines, it has to get investigated by a federal agency. So if 2Mad committed crimes in 2 states, that would be a higher up court. Higher up agency. It would not be the local police department of this state working with the local police department of that state. That's not how it works. But, if you want to believe him for that, then you can. But here's the proof right here. The overwhelming majority of crimes in the United States are investigated and prosecuted by state agencies, but crimes that cross state lines or involve violations of federal laws are investigated by Department of Justice and its federal investigative agencies. This would be your FBI, your DEA, and ATFE if it involves firearms. So, organizations like that. But that didn't happen. And definitely if it was escalated to the FBI, no FBI agent is giving James Key any amount of information on anything. Before I get deeper into it, James Key slid in my DMs. I mentioned it on live stream, and he basically hit me with the trust me, bro. Now, he did this strategically because he can see there was some dissension, and I was definitely not believing everything he said because, on my channel, guys, if you don't know, I do not believe all women. I do not believe all men, but I do believe all evidence. That is true. So this is what he said to me in DM. What does he say? Hey, Henry, I've been told a few times you've been covering some of the 2Mat related stuff when it was happening. Thanks for raising awareness. Now look at this. Thanks for raising awareness, man. Like, oh man, he's so happy because if you don't know, early on when I was covering 2Mat, I was hard on him. I was calling 2Mat a POS. I said he was going to jail, biggest mistake of his life. He just could not get things together. So I was very anti 2Mat early on. I don't think anyone else has been doing it unless I've missed it, and I'm legit surprised how many bigots didn't even bother looking up stuff and just blindly believe 2Mat for months despite all the stuff being out there. Now look, he's saying all this, but he never provided any court documents or any court case for people to look up or direct them in any direction. All of that was absolutely tragic, and there has been a lot of effort put in by the guy to stall off the case as long as possible to cause financial burden. It's insane. This is a false statement. And the only reason I know this is because I have the court transcripts. The case was delayed approximately one time because of James Key's lawyer pulled a bait and switch right before hearing. I assume you've kind of picked up on that just from the docs and how the dates kept getting pushed back. Only got pushed back once. I got sent your tweet about the con. I figured I'd reach out to clarify directly that it actually got bad. Like, I don't even know how much I'm allowed to say, but I think I can trust you not to leak my text to the public. Well, that went out the window when you insulted me. It did get really effing bad to the point we couldn't go to certain locations and multiple units had to keep me safe in remote locations. Now, this is just him re-uttering everything he said publicly. There's no new information over here. He's basically saying, hey, trust me, bro. Like, it wasn't just people assuming stuff like, well, a lot of people are assuming stuff. There isn't much of it in the docs, so I can see why it led to your assumption. Like, bro, I saw what you told Las Vegas Police Department. None of what you said will warrant a huge police presence. And the fact that 2Mat's lawyer said there's something very similar when we get to it about you using his tweets to corroborate direct threats, in which eventually was dropped by your team. So if you had a clear-cut case to put him in jail, you would have taken it, right? No, you didn't. I know multiple creators came forward confirming that it's real, but I hope you can trust me. Look, I do not trust you as far as I can throw you. Show me proof or no shot. That there's been a lot of stuff going on outside of just the one case you've been covering. Well, we covered two. We covered yours as well. And I hope there's no bad blood between us at all. This situation is absolutely terrible. I wish it didn't go the way it did. Well, I kind of think you do wish it went the way it did, because with less than 30 minutes, you called him a pedo, said he was a rapist, and that he allegedly made an attempt on your life. To avoid any confusion, I'll say that I hope I didn't come across as if I'm celebrating 2Mat's death. I'm not. I thought it was some kind of obvious, but his fan base keeps twisting my words, either knowingly or just parroting what some people say, even if it's not true. Well, you have yet to show any proof of him being a pedo, any proof of him making any attempts on your life. So why should anyone believe you other than the fact you got other people saying, yo, we really saw police presence at TwitchCon? To be fully direct and honest, I have nothing to gain from it, and I never did. You're right. I mean, you did gain a lot of impressions, and you know, your story was picked up nationally. So, I mean, sure, you didn't gain anything, I'm sure, right? I've been helping people dealing with heavy and sensitive stuff for years out of personal belief. So he sounds like Mama Max right here. I'm getting some real Mama Max vibes, but just this time he got a lot of traction, which is unfortunate because I didn't want any victims to be in the spotlight. Now, this is a bald-faced lie because for the longest time, all the victims or the victim Goldilocks was posted on his freaking Twitter page, right? And when we get to more of that, you'll see more people just pinned there for him. And I thought you wanted privacy, but you kind of looks like you want clout. This is what I say. Hey, in DMs, I'm very brief. Hey, thanks for reaching out. Do you want to do an interview? Does not have to be live, just you and me having a conversation. And he says, yeah, no problem, man. And sorry, I can't. He could, but he won't. Okay, because he can create these documents that, you know, sway public opinion to say that 2Matt was horrible. And yes, he was unhinged. He made a lot of unhinged comments. And here are one of his harassment victims, Stella, great content creator. I've watched her before. And hey, guess what? Where's this at? This is reposted on Jameskey, and it's also what he wrote to her is in his 52-page manifesto. And if you scroll down just a little bit, oh, there go Kiwi. Hey, let's keep the victims private. Well, you're also trying to use the victims to, you know, vilify 2Matt. I mean, look, guys, I don't support any of the harassment whatsoever, but here we are. So now let's get into the court docs. This pretty much started this whole $25,000, which is omitted from the 52-page manifesto, is because Jameskey will not show you the civil cover sheet. On the civil cover sheet, it is selected the amount demanded exceeds $25,000. Now, sure, he said, well, we can go for little money, and he pulled up the law saying, you know, that it's normally used for some other things, but he did have the ability to demand no money and chose not to. So this is the civil case cover sheet. And remember, this all started from this restraining order right here. And this at the time requested by Goldilocks. 2Matt was living in a 5-bedroom, 5-bathroom little mini mansion in LA. Quite quaint, if you will. And Jameskey inserted himself in it. Now, look, you want to note that as of recently, I did check the LA County Court, and 2Matt has no criminal record in LA. But what did it say right here? This is where Jameskey conveniently inserted himself in this girl's petition, lawsuit, whatever you want to call it. I don't really want to get into the semantics of things. December 2021 through present, respondents' online threats, harassment viewable to the public and attached to this petition. Respondents' private threats to me have been witnessed by my friend Igor Lamsky, you know, Jameskey, inserted himself because he's paying for it out of hatred and jealousy for 2Matt, not because he necessarily cares about Goldilocks. Now, the most important thing in here, you do have like her statements of him saying that, you know, he put a gun on her while she was on the porch, which we all know was a BB gun, essayed her on multiple occasions, things like that. This is Goldilocks' request, but more importantly, you know, her statements, if you will. Here is her statement. And, you know, I did have some questions. I hate when they put shortly after I turned 18 years. 18 is an adult. It's manipulative language that gives me, you know, that girl from the George Not Found stuff where she was freshly 18.
Also, the fact that I said I was freshly 18, which is something a lot of people are mad about, when in reality, I was 18 and 5 months old. My bad. And,
you know, he manipulated her into coming to the house to visit, although we did see the text messages that said it was a transactional relationship. Even though Jameskey is saying, well, all those messages are fake. And we saw no proof of that. Whereas the forensic person who did the confirmation that they were fake, I mean, it's about big as a book. Anytime I've ever seen anything disproved, it wasn't about as big as a book, but, you know, who knows? The text message says she was there for it, but, you know, it's her word versus his. You know, dead man tell no tales. How does one manipulate one for several weeks? You have things like that. And, you know, people say, well, you're victim shaming. Like, bro, she wasn't living with them. She wasn't a prisoner. She could have left at any time. And I know there's the incident where she said that he was cornered in there. Possibly, you know, she said she would have sex with him because she liked him. And this was in the Gokinaru interview where Two-Mat recorded her, which James Key said any evidence that supports Two-Mat and them having a relationship is fabricated with no proof. I can see Two-Mat based on what the extensive research I did and watching most of his old interviews. I'm not going to say all of him finding things funny that most people would not, you know. And the video never says for SA. This is the video where he allegedly apologized for mistreating her. This is part 2 of her statement. There was something I did believe over the several last months. Two-Mat harassed and stalked me, making several threats for my safety. Responding threats and harassment has become more and more alarming over the past 2 weeks. In the past, he showed up at my apartment unannounced, and recently, as 4 days ago, under information, I believe he sent a package to my parents' address. Okay, yeah, I think he did this shit. In all honesty, it's horrible. But, you know, they seem to have like a toxic relationship. But, you know, this is me on the outside looking in because of the interviews that he did and the new text messages that I have where he describes their relationship. Everyone agrees that the restraining order was warranted, even if some of the evidence is grossly out of context. Like I said, I always agreed that it was warranted, even though they're using BB guns and making them seem like real guns. But, you know, the harassment was very real. I remember reading this, like, what an idiot of Two-Mat to do. Yeah. During the case, he would tweet things and say things. And oftentimes, as soon as he would get a response out of whoever he was talking to, he would say, oh, no, I'm just playing. And it just really makes it hard for me to defend him, but I'm not defending his harassment, only the pedo. And I just want you guys to have a full clear-cut case of everything that was said about Two-Mat. I said in a previous video that there was a picture of him shooting a firearm, right? This came up not only in the petition, but it also came up in court. And I said the video was edited. What the fuck? Okay, I've stood by it since I started digging into it. No way shooting in his neighborhood, no police show up. He actually, you guys going to see later that he confirmed that, yeah, that video of him shooting a gun was fancy editing. Also left out of James Key's 52-page manifesto. This is considered, can be considered lying by omission.
A lie of omission. Leaving something out for your own benefit and your own gain is still lying.
I think the harassment was real and she did likely probably fear for her life. So how do you get the court documents? There is a link in the description to the Los Angeles County Superior Court of California. And what you want to do is you want to continue as a guest. You don't need to create an account like I did or anything like that. You can click, hey, I want to continue as a guest, right? And what you want to do, you want to search for document images, right? And when you search for document images, you will be greeted by this, right? You type in the case number, which is 23STRO04319. You type that in and you get to this page right here. Now, what you're going to see is this page is going to come up, right? These are all the documents that are associated with the case. Now, notice there is no motion to seal. The case is 100% open to the public for anyone to look at, as I always thought it was, even though someone said the transcripts are confidential, which they are 100% not.
That was a lie.
They were in the judge for a total of 4 times. Now, what if you don't search by that? You search by his name. If you search by his name, you're going to get this page with all the case information. The case information, you're going to see literally everything that happened. Basically, this is just the cliff notes of the case, if you will. Every time they met up, every time they talked, the register of actions, you're going to see all the court paperwork. You're pretty much going to get a great overview of the case. But what happened? They met in front of a judge on Friday, July 28th, on November 17th, September 26th, and the big one is December 5th, right? Let's get into how to request the transcripts. Now, if you follow the link and you want the transcripts, this is how you got to go and do it. Now, I did a voicemail request, and it's going to take you to this page, right? You click voicemail request. You're going to call this number, right? And you're going to click right here. There's going to be a voicemail directory. And what you want to do is if you requested the court docs and you go to the meeting minutes, there's going to be a name right here. This is your court reporter. You want to reach out to them and say, hey, I want meeting minutes from this day, right? Because these are the days that they had a hearing right here. And once you do that, it's only really 2 names that you really need to do. Now, when I did it, this is what I sent them, right? This is how I did it. Because this person, the first person, they had 3 out of the 4 dates. So I say, hey, I put the court case in the subject line. I was ordering the court transcripts. Hey, look, I would like to request a copy of the court transcripts from the following dates. And you have these dates. Now, look, me, I goofed up. I goofed up. And this date is actually not a court date. And they respond, hey, thank you. My transcripts are certified, sent in electronic form as a PDF. And for the date, November 26th, that day is a Sunday. Therefore, is there no day? But she gives the price and expedited. It was $166. And that was for 10 days. But, you know, me, I responded and, you know, she drops her Cash App and her Zelle. OK, but I'm like, look, I'm sorry. That date is for the 26th. I would like them expedited because when a lie is just running rampant through the community, I wanted them right away. And I wanted it for the correct date, September 26th. OK, so she said, look, if you want it in 5 days, it's going to be $321. So what I do, hey, I would like the transcripts as soon as possible. I sent you $321 via Zelle, you know, because to see what was going on and see what Jamesky was lying about or omitting from his 52-man page of trust me, bro, was worth it. And here is my receipt. And hey, she was like, hey, thank you for a payment. Attached, please find the transcripts for the above entitled court case dates. 100% open to the public. OK, so I made the other request for the 4th one, and this one was only $16. And same thing. She got it to me right away. And I appreciate them in their fast response to get everything to me. Now, if you want what happened in Las Vegas right here, this link is also in the description. And this, look, I requested the original ones, but they just did not get to me back fast enough. The case number is 23PO2446. And this is between Jamesky and Too Mad. And when you look at this, you're like, he said there was a huge police presence at TwitchCon for basically what you would assume is this report, right? Because this is the only thing that's listed, him requesting a restraining order based on Too Mad coming there. But the statements they do not warrant a huge police response. They do not. Here's his statements. Their statement 1, as he references Goldilocks case, which he put himself down as a witness to. Here's the main statement where he talks about he's in fear for his life because Too Mad has shown pictures of firearms in the past and he's coming to TwitchCon and he's banned. Same for Aiden Ross. I know Aiden Ross went there. But here's everything that he said. Now, I've covered this in previous videos, right? I really did. And I'm not going to read it again. If you want to pause the video and read it, go for it. And there's 2 other statements right here where he talks about 4 years ago. Now, in this statement, in the last statement, he never references anything about Too Mad making a direct threat on his life. So how he comes out the woodwork saying Too Mad wants him gone is beyond me. Is beyond me, right? So you have these 2 statements, and this is pretty much the end of the document, barring the signature and the what he wants it for up to 2 years and all the other stuff that is in previous videos. Now let's get to his 52-page manifesto before we get into what happened in court. Now, look, guys, when I read this, I'm reading it with the knowledge of everything that was submitted in court. I'm reading it with the knowledge of everything that was said in court. I'm reading it with the knowledge of watching all of his interviews well, not all, most. Most importantly, the 2 ones you really need to watch is the one with Gokunaru and Turkey Tom. the one with Kankomar, and if you want his friend's perspective, look for the Jamie Pine interview. Those are the interviews where 2Mads talks, and he was not taken out of context, because he definitely said that stuff. I'm not gonna say, hey, he didn't say it. But what happened was he was cherry picked. So it's kind of like the Bible, right? If you believe everything that 2Mads says is true, if he says he did action A and then 2 minutes later he says he didn't do action A, which one are you going to believe? That he did it or he didn't? It's up to you to decide. So let's get into it. I'm not going to spend too much time on this because we really need to get to the court transcripts. So what did I say? Is there any proof that he tried to delete Jamesky in here? I did not see any. You know, as a former investigator, that's something that would stand out. Is there a proof that he was a pedo? Notice how there's no mention of that, which is highly defamatory. And if I was 2Mads family, I would definitely be thinking about litigation. There is no physical proof of him being a rapist. I mean, that's going to be her word versus his. And I know he jokes about some stuff like that. And if you think he's a rapist, he's not joking. If you don't think he's a rapist, you say he's joking. That's for you guys to argue about. But when I say, hey, this document is full of falsehoods, lies, and blatant exaggerations, okay? This dives into the critical analysis of 2Mads' crimes, obviously, I mean, which is ironic because he has no criminal record in LA, both online and in person, that have, you know, profoundly impacted victims' lives. I urge readers to approach the content with care and empathy. 2Mad has no criminal record in LA. This is a factual statement. You can check right now. Please respect the privacy of the victims. Leave them out. No one asked for privacy until 2Mad was dead. While 2Mad was alive, you know, Igor and Goldilocks wanted everyone to know who his victim was, and they were the ones who had the restraining order, and they were pursuing, and they had the tweets pinned to their Twitter comments. Now, Goldilocks has since deleted and or changed her title. Now, in the meantime, in between time, when my stance switched up on all of this, I get a privacy complaint from YouTube, right? So to take some videos down. Now, look, I didn't take all the videos down. I took 2 videos down, but all those court documents are going to be in this one. That's why you don't see any names outside of 2Mads. Now, since I've censored these videos, I haven't heard anything back. So I'm guessing I'm good, but this was definitely a bish move on their end, because what happened was they didn't like the stance I took. And as a result, she slid into my DMs, right? So she's like, look, this is blah, 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 also known as Goldilocks. It's nice to meet you, right? I appreciate your coverage of the case, same as Jamesky, involving 2Mad and myself over the past 6 months, because I have been covering it for 6 months with court docs. With the news recently of 2Mad's passing, I wanted to contact you. Like, no, I mean, they knew the tide was changing. I talked to other people who have been covering 2Mad's online, and the consensus is they don't want to cover the news yet, so his family can grieve. Okay, like, I don't know why content creators will be in contact with her. But anywho, I don't wish to be in the spotlight anymore. She need to say anymore and have my face or legal name included if you choose to make a video or live stream. Now, the previous videos had her face on thumbnails and had her name in there, all that good stuff, and it was no issue whatsoever. I've been unable to live in peace, and my family has been getting harassed ever since my full name was revealed. Now, if you Google her full name, you're not going to find out where she lives. It's not like she's not the only person in the world with that name. I hope I would have gotten peace from the justice system, not from his passing. I don't wish to make any statements for you to publicize that I'm reaching out to you. All I ask is for censorship of my identity as a victim during this time. I hope you can understand my situation and this request. Now, look, sure, I will censor your name moving forward. The picture shit, the shit's already online. And she says, hey, thank you. I appreciate keeping the good work. And then when my video dropped, you know, I'll be honest, there was some spots where her name got through and her picture was definitely up in there because that shit's online. Your newest video has my face in the thumbnail, has my name in it, and you said disgusting, slanderous comments. I don't have any idea what you are covering and are spreading mortifyingly false information publicly. James will be posting an extensive video that he has been working on this entire time to explain the situation properly. I am disgusted by what you have said and how you have treated me. It's absolutely unbelievable. Now, look, I think what she's mad about is the fact that the text messages came out about her agreeing to drop neck for $200. Well, if those pissed you off, I got a bunch more coming because he actually texts friends about the transactional relationship. that he had with her. With that out the way, let's get through his 52-page manifesto. We're going to try to make this quick and concise. When he goes through and look at this, talking about a real Glock and AR-15 was done by some investigation. He doesn't name any agency. There's no dates. There's nothing other than a huge trust me, bro. And I likely think he just got this by putting were found in there. That's mostly Jamesky's story. That's mostly Jamesky's evidence is what 2Matt would tweet. There's no like, oh, phone conversation or anything like that 2Matt had. You have the Gokunaro interview and the tweets. That's basically it for the most part. Oh, Kankomore too. But most of Kankomore is just talking about drug use. Now, the LAPD did not refuse to take 2Matt's guns, okay? This is just not true, okay? Him posting pictures of guns on Twitter does not meet probable cause for someone's house to be searched. This right here, and like the judge really never said anything about the whole firearms until the last court case. It was never the last hearing. It was never like, oh, we need to go get his guns right now. Okay. And that was on the December 5th. Now, look, guys, anything without a police report, I would treat as hearsay, which is most of this document. Do you think the DA of any county, state would keep Jamesky up to date on their operations? Like literally think critically about that, because he's, oh, this investigation, this and that. Look, Jamesky is the Mama Max of 2Matt victims. He has one official harassment victim, but outside of that, nothing much else. I wish more people would call him out, but I know he wants to fancy himself as a white knight. But it just shows that him and perhaps maybe Goldilocks were really obsessed with 2Matt. The document, is a true testament to it. If from my point of view, at no point in this document, and I want to make it crystal clear, does anyone even remotely come close to an attempt that 2Matt made on Jamesky's life. I don't see it. Maybe I'm blind. Maybe you can message me. Hey, at this point, he said, hey, I am going to hurt Jamesky and or Goldilocks because his lawyer was vehemently against that 2Matt ever threatened anyone on Twitter. So let's keep going through it, and if I was his family, I would sue Jamesky for defamation, especially regarding the pedo complaints. Now, on page 18, he kind of tells on himself right here, where he talks about the government handled the visual evidence for SA in a separate criminal case. The civil restraining order only included the information necessary to protect the victim, not prosecute 2Matt. The authorities don't casually give out information about criminal investigations to strangers, let alone provide the public with sensitive evidence submitted by victims. So why would they tell him? Does that make sense? Maybe it doesn't. We can keep going. I do have some things I would like to shed light on. Now, this whole 2Matt was advised to take the 5th. This is completely out of context. This is regarding being served. Not necessarily him admitting to committing a crime. There was some discrepancy of whether he was served the contempt file, and that basically mirrored everything that Jamesky told Las Vegas PD, including, more pictures of airsoft BB guns. They're talking about this whole, the relationship of it thing or whatever. Like, there was never a relationship. It was made up by delusional offender. Like, this is another defamatory statement. He was never charged with any offender crimes and were shut down by the judge. This never happened in the civil case. The judge didn't shut anything down. In fact, 2Matt doubled down and basically called her a prostitute in court. And the only thing happened was her lawyer objected, but the case, 2Matt continued talking. So, you'll see when you see the court transcripts, and there's also a clip in the Gokunaro interview where she admitted that she would sleep with him. But, he said, oh, that's a deep fake now. Oh, okay, man. Pretty much any evidence that supports 2Matt being there. And on top of that, there are other text messages that show that she was there to drop neck, or, in some capacity. That was his thing. This is a text message where he talks about how, hey, for $250, she's willing to come outside and drop neck. And it continues on and talked about, basically she giving him a couple BJs and calling it a day per se. right here. Hey, when I said let's be friends, it's like she turned into a new level. The key turn, she gave me a BJ in the next few minutes. From me thinking it won't happen, I did not expect it. Her to just flip a script in front of me. Does she think I don't see her? Now look, we can go deeper into this in the live stream, but let's continue through this document.
He sent pictures and videos to me of him and Bella doing ketamine and cocaine. He was paying her $1,000 to come hang out at his house and do drugs with him.
Base, you know why she said $4 a chicken nugget? She brought up money because I was gonna pay her for I dated a prostitute, and she's like, "No, you didn't pay me for anything." She's like, "Yes, I did." I was like, "I'll buy you dresses," and she was like, "Oh my God, I love you for who you are." This bitch.
The whole "hey, we didn't ask for money" thing just keeps coming up, and he lies by omission, so he didn't show you the civil case cover sheet, which clearly says right there that, you know, this was completed. You see the same case number. They didn't check limited amount, which was 25,000 or less. They checked the amount exceeded 25,000. Now, if you think he's going to almost go bankrupt and not ask for no money in return because he's just such a nice guy, I do have a bridge in Brooklyn that I can sell you. Also, when it comes to all these police reports, I imagine they are mostly tweets. Tweets. He omits this as well from the report, so I guess we will never know. Now, this whole, I believe he gets into like the courts instructing the cops to go arrest him. No.
That was a lie.
At no point in any hearing did the judge say Too Mad is to be arrested, okay? When someone wants to be arrested, it's not like a verbal, "hey, go arrest them." You have to create a warrant for their arrest for a potential crime that they committed. You have to have the evidence of them breaking the law, which never happened in court. This is, like I said, the vilification of Too Mad. But you don't have to trust me, bro, because I'm going to show you the actual court docs. When it comes to this whole LAPD didn't do their job, Jamesky's lawyer was in front of a judge a total of 4 times. At no point during any hearing did any of Jamesky's lawyer ever say, "hey, LAP is not doing their job." Problem is, no one's going to arrest or search someone's property because someone tweeted something, especially when it does not have your name or anything like that in it. So you can't just reach and say, "well, he tweeted this, we need to go pick him up." It does not work like that. We're in America. As far as this firearm conspiracy theory, look guys, if Too Mad is really pushing illegal firearms, they're not going to sit and wait around to look for his supplier or anything like that. ATF will be up and through his door, kicking that shit down ASAP. FBI, open up! He would definitely get arrested. There would definitely be a arrest warrant, a federal arrest for him, which I did not see when I searched the Federal Registry. Also, something to take away from this, guys, the lawyer just walked out and he represented himself pro per. This is true, but the lawyer didn't walk out. Too Mad stated that he did not want a lawyer and he did not need one. Now, to be fair, this restraining order was going to go through no matter what. Too Mad reading a ChatGPT that the judge instantly shot down. This is another lie. This did not happen whatsoever. Okay, he was not caught lying. He described their relationship as meeting on a prostitution website. Jamesky's lawyer objected, but Too Mad just kept cooking. So you're going to see that also, and we can go straight to the last page where he says, where he tries to low-key try to play me and accuse me of not including his 2019 manifesto, his Trust Me Bro manifesto. Where it was a lot of evidence to support some narrative. But like I said, no physical evidence, all this other stuff. But, these are real victims with real lives and families that some of those clowns are dragging through the dirt. Now, to be fair, they were all on my when I was going through and bashing Too Mad. It wasn't until I switched tone when I switched my tone and put out this video that they hit me with this fake ass privacy request to get videos taken out. Okay. And, you know, I deleted 2 of them, but, you know, all the information is in this video with all names redacted. So I shouldn't have to worry about that again. But, you know, the only clown I see is Jameski as he's continuously tries to railroad 2Matt. Let's get into the court transcripts, the skinny of things, if you will. This is July 28th. They were in front of the judge. Remember, they were in front of the judge a total of 4 times, okay? Right here, you have the 28th, September 26th, November 17th, and December 5th. So what happened on the 28th? Now, this is pretty standard. Nothing major other than out the gate, they agreed to push the court case to the 26th. Let's push the hearing to the 26th, and they acknowledge that, hey, there's also a pending criminal investigation. They're looking at 2Matt like a criminal, but not because of anything like this. So everyone was in agreement. So they move it to the 26th at 8:30 a.m. Now you're probably wondering, well, when did I get this? I got this on the 21st of March, 2024. These are 100% open to the public, okay? Nothing is confidential. You can get it. You can get it yourself if you want to see the unredacted version, which, you know, if you want to see that, go for it. You don't have to trust me, bro, for anything. Let's go to the second court date, which was the 26th, right? What happened this day? This was a bigger day. A lot more happened, nothing too out of the ordinary. 2Matt was not there. He was actually in the cafeteria, and this is actually going to come up. But what happened? Hey, 2Matt's lawyer said, hey, 2Matt is not here. So what does California Gov Code 69954 mean, right? It really generally only applies to the selling or copying to other parties or persons if you purchase a court transcript. It does not mean that it's confidential like Jameski alluded to or omitted or anything like that. And if you're familiar with LawTube and you go to channels like Emily D. Baker or let's say a Rakita Law or even a lead attorney, it's not uncommon for them to just read court transcripts because they're a public record and also court documents, and they don't even redact anything because, you know, they have a big enough following, so a frivolous privacy complaint could just easily be gone, eliminated. But me, I have to eliminate all names just to avoid anything like that. So guys, I'm not going to sell you a copy or anything like that, but this is what the code means. What would I like? Hey, I would like to get a continuance. And yes, my client is under a criminal investigation for serious strike offenses. California has a 3-strike rule. This is completely independent of Jameski because they didn't even know about it. That's right. Their lawyer had no idea that it was this serious, okay? And you had other reasons for the continuance, so the court is inclined to grant the request. So the court automatically is on 2Matt's side for continuance. That is, this is where Jameski's lawyer tries to pulls a fast one. Hey.
Thank you, Your Honor. My client has already agreed to a continuance in this case. So, almost 2 months ago, and in that 2-month period, the respondent has continued to harass my client online, including this morning, where he's sitting upstairs in the cafeteria tweeting pictures of people.
Yes, 2Matt did tweet about this, guys. Not the brightest crayon in the box, but, you know.
People holding weapons. Enough is enough, Your Honor. My client has been through enough. She's here today. She's ready to move forward so she can move on with her life.
Seems very, very, very intense, right? But the court, you know, judge is a little based.
All right. Well, there's a temporary restraining order in place, correct? So if the hearing were to proceed, the same protections that would be issued by this court are already in existence. So I'm not sure how you're prejudiced by the continuance because the restraining order is in place.
So basically the judge is saying you already have a restraining order in place. There's nothing that I could do that's going to stop anything. So it's still going to be in place.
Your Honor, this date was picked by the respondent, and I think the respondent would benefit from understanding the seriousness of this matter from Your Honor.
So he's like, hey, he needs to hear this from you. Now, 2Matt does have a decent attorney.
A couple things on that.
Yes,
Yes, there's no proof of anything that he's done. I've been in communication throughout the past month and a half, however long it's been, with petitioner's counsel. I've been in communication with my client, of course. Listen, First of all, I don't know why petitioner is looking at my client's Twitter or whatever social media accounts, first of all. But secondly, he has a First Amendment right to tweet as long as, of course, it's not a direct threat to her, and it's not, what she considers subjective harassment. That's not to be litigated here today, and counsel has recourses. So I agree with the court that there is no prejudice and harm. There's a pending criminal case. There's a lot of other issues that need to be resolved before we go forward. But, I think at this point, and I understand their desire to go forward, I will continue to have conversations with my client, not to have any contact, not to harass her in any way whatsoever, but just lastly, on the date. This was a mutually agreed upon date on a mutual agreed upon continuance. We have been in talks to resolve this case for the entirety of the time that we continued it. And then, all of a sudden this past Saturday, counsel indicated that those talks were off and they wished to go forward. So I think given that, a continuance is appropriate.
Right.
Your Honor, the only other thing I will add is that there is evidence of this. Tons of it. I have it in my binder. There are direct attempted communications to my client since the order has been in place.
So remember, their biggest piece of evidence is, hey, he tried to call her, which it doesn't seem like he was successful.
All right. Well, fine. If the order was issued today, it wouldn't stop those communications. The same remedy that you have today is the same remedy you would have after the permanent restraining order was issued if it were. Meaning, you call the police and report those violations.
Now, keep in mind, Too Mad would post a firearm. I imagine Igor telling Goldilocks to call the police. If he tweeted a firearm in which no one could verify it was real or fake, I imagine some of those police reports are related to tweets, because there is no saying that, hey, he spoke to her. So you have that. Police ain't acting on no goddamn tweets.
All right. And what type of continuance are you seeking, counsel?
Really, whatever the court can give me. I mean, if it has to go 21 days out, but there's still going to be a pending criminal investigation. I don't anticipate that's going to be resolved, so I would ask for, and there's a time waiver from respondent. I would ask for, at least 60 days.
Lamsky uses this knowledge to say Too Mad was a criminal. Too Mad has no criminal record, guys. No criminal record. The court, well, I would think that, especially if it hasn't been charged or arraigned yet. So at this point, Too Mad has not been charged, okay? Or arraigned or anything like that. And with him passing, he will never have a criminal record. I agree. The court. And then I just note, just housekeeping, the judicial officer before me who issued the restraining order didn't put a distance in the stay away. So that's going to be a minute to 100 yards, which is standard and fair. Too Mad's lawyer says, stipulated, no problem. And we have a 60-day date, which is December 5th. And all is well. They accept service. The case goes on. And now the next hearing is on December 5th. And this was given to me March 19th.
Oh my God, bro. Oh, hell no.
Now, this is a bigger one because this date they do get involved in some back and forth regarding whether Too Mad was served or not. That's the big issue. Was Too Mad served? So this is the November 17th one where pretty much Too Mad was there, her lawyer was there, Too Mad's lawyer was there. This is the whole was Too Mad served contempt issue in the whole did he plead the fifth, if you will. So let's go through it. We're going to kind of paraphrase because it does get a little bogged down early on. in the beginning with them just calling Two Mad, just trying to get him on the phone. I'm specially appearing today. So now Two Mad's lawyer is on special appearance and they're trying to get Two Mad on the phone. Okay. Hey, you're on Court Connect this morning with us. Two Mad. Yes. Now keep in mind what Two Mad is saying. He says, yeah. He says, yes, because Jamesky said, oh, his lawyer had to shut him up. So everyone gets sworn in.
Okay, so we're here on an order to show cause re contempt. But I understand respondent is asking for a continuance. Is that right?
It's very complicated and convoluted. Counsel and I have discussed this. This is a criminal matter. As you might know, I handle a fair amount of contempt, civil contempts, and I'm a criminal nature by criminal defense, attorney by nature, or my general practice. First of all, with regard to the arraignment today and the reason I'm appearing on limited scope, I believe there's a doubt as to my client's competency per Penal Code Section 1368 that needs to be addressed at a later date because there's some attorney-client issues.
At this point, the relationship is souring between Two Mad's lawyer and Two Mad, likely over money. We'll get to it later. And the whole competency thing is Two Mad mentally competent to understand being served? It's going to come up later.
Anyhow, to short-circuit it, Your Honor, petitioner has a pending. I don't know if it's a DV or CARO against respondent, but it's scheduled for December the 5th. So we were ask to just continue the arraignment on the contempt to that date. But I also, for that date, and the JA may want to pay attention, but he's probably going to need legal counsel appointed for the contempt. And I know the public defender's office is not taking these cases anymore. I don't know if he qualifies, but what's called bar panel. I forget the acronym that they go by now, but they are appointed attorneys who are taking these cases for indigent clients.
So because it's a contempt charge, criminal charge, he has the right to an attorney. Clients who can't afford a lawyer is an indignant client. They go back and forth about the appearance of Two Mad's lawyer. And it comes down, he's like, look, man, I'm just here on a special appearance.
I represent him still in the Devereaux. And one of the problems is I accepted service on behalf of the respondent for the contempt.
Now, typically, if you're in a long case, it's no issue for your lawyer to accept service, provided you're still going to have that lawyer.
That contempt, and I have since, let me put it this way, the status of my representation is a little uncertain. All right? If I don't represent him for the contempt, I'm not authorized to personally accept it on his behalf, and he has to personally be served with the contempt. So that's why, additionally, why I suggested it, go over to the next date.
You see how it works? If Two Mad was never served, technically they can't really have a contempt hearing, especially if Two Mad's lawyer is gone.
I don't see in my file proof of service on the contempt at all. Does counsel for petitioner have a proof of service for the contempt?
Yes, I have prepared one. Counsel accepted service on his client's behalf back in October. And now, for the first time, I'm hearing that you are admitting you accepted service, correct? The respondent has showed up today. He signed up for court call appearance on November 3rd. So to say now, after his attorney. And he was his attorney at the time of service. Accepted for. The petition on his behalf is a little astounding to me. But it's a red herring, I think, Your Honor. I would like to get to the merits because the situation is urgent, and my client is not safe right now.
I mean, they keep saying they're not safe, but any final restraining order is going to be the same. But it's interesting that they say she's not safe right now, but they later dropped this contempt hearing, which if he was held in contempt, he would likely been arrested and sent to jail. So if she's not safe now, wouldn't she be safer if he was in jail?
There's a temporary restraining order in effect, though. Is that right? Okay. And let me get to the bottom of this service. I don't have a proof of service. So even if you served Mr. 2, Mad's lawyer, or another counsel, we have not, I don't have one that was filed today. And then, my question for Mr. 2, Mad lawyer, are you, on behalf of the respondent, contesting the service of the contempt?
Yeah. It's going to be an issue later, because if I'm not representing him in the contempt action, I, thereby, become a witness for service. So
we're talking attorney-client privileges. Your own lawyer cannot testify against you in any capacity. Did you represent to the counsel for a petitioner that you would accept service on his behalf? Yeah. The court. Did you accept service on his behalf? Yes, I did. Their lawyer chimes in. I have it in writing, Your Honor. Look, no one is arguing. His lawyer is basically saying, look, I accepted service, but our relationship is strained. I don't know if I'll be here for a contempt hearing. Okay? And he tries to explain it out. Look, if I no longer represent 2 Mad, there becomes an issue of service if he's not personally served, because he has to be for contempt. 2 Mad chimes in. Look at 2 Mad. 2 Mad right here. Hey, he's listening to this. He's not an idiot as much as people like to think. I can waive the 2 Mad wants to be considered served. The court, but you, hang on, sir. The court hold on. You have already agreed to accept service on this behalf. Yes. Okay, let me ask you this. Let me have the parties raise their right hand and be sworn in. So they swore him in again. After they get sworn in, his attorney is looking out for him. Before the court addresses him, I'm advising him to take the fifth and not answer any questions, because he's actually trying to look out for him. I'm not aware of any pending criminal investigation, Your Honor. You see how it works? 11-17-24, Igor's lawyer. Not aware of any criminal investigation. 2 Mad equals 2 Mad's alleged crimes do not involve Goldilocks or Igor. See how it works? 2 Mad's lawyer. Well, all right. That's good. The court. Okay. In terms of service issue, I think for counsel for the respondent to represent that service was accepted on behalf of 2 Mad, I'm going to accept that today and then deem that there has been service, because it seems that neither counsel is disputing that 2 Mad agreed to accept service on his behalf. If 2 Mad is disputing that, he agreed to accept service. 2 Mad's lawyer says, hey, look, I have no idea. 2 Mad, I have reviewed the case. Look, he's going on. The court, when you say you have reviewed the case, sir, well, let me clarify. Did you take the oath so you understand that you're under oath at this time? Yes. 2 Mad is like, yeah, I understand. This is like 3 times he's spoken now. Now his lawyer's like, look,
I can waive the...
I'm sorry. If the court is going to ask him about service, the court needs to be admonished of his Fifth Amendment rights, and he needs to knowingly and intelligently waive them, and I'm representing to the court. That's why this case is complicated. I've never dealt with this issue, but I'm very familiar in dealing with it in criminal court. So I'm putting forth to the court that I don't believe he has a competency to knowingly and intelligently waive his Fifth Amendment rights. So I don't want to create any promelve for your honor today.
His lawyer is like, look, I don't know if he understands what being served is, and I don't know if he can competently waive his right. Now you can say maybe this lawyer is looking out for him because he can get a lawyer and extend the case. 2 Mad's lawyer is likely not getting paid and is on the brink of not representing 2 Mad. So he wants 2 Mad likely to get a new lawyer. Now, long story short, 2 Mad ends up accepting service. I just think ethically, I'm not allowed to put myself in a position where I become a witness to the case. I'm not supposed to, at least, and I have to. They are pushing for him to be served. Your Honor. Take every avenue to avoid that. Your Honor. They're just crying. So that's all. Your Honor. 2 Mad's lawyer was his attorney up for the record at the time of service. He accepted service. He acknowledges today that he accepted service on behalf of his client. And I think we just heard the respondent himself say he's willing to waive the issue. So I don't see what the problem is here. The client is clearly served, and he admits so today. Now look, Tumat actually has a decent lawyer, man. If I'm in LA, I probably would go for this guy. It's not an issue that we need to really address the service issue. I agree with counsel, and I would come back here and say that I accepted service on his behalf. But the court has to understand that I can't divulge what I did with it. Whether or not I've communicated with my client about the document, that attorney-client privilege or the communications I've had with him regarding the document that I accepted, and secondarily, either way, regardless of the service issue, we're not prepared to go forward with the arraignment today on the contempt. And that we're asking for a continuance on that. So any potential issues with service could just easily be taken up at the next court date. Now, the court is like, well, in terms of not being prepared for today's hearing, what efforts without divulging attorney-client privilege need to be made before the arraignment can occur? Well, he needs to be, I'm not retained to represent him for the arraignment. For one thing, you see, this is where the money comes into play. Tumat hit him up for the domestic violence restraining order, and then the contempt thing pop up. This is a whole nother scope. I've dealt with this with my legal issues in my divorce. And overall, he's here today. Again, I'm stating to the court that I don't believe that he has the capacity to understand the nature of the proceedings today and cannot proceed on his behalf. This is covering his ass. This is some CYA stuff. I don't understand why Tumat wouldn't understand it being served, but also Tumat cannot proceed in pro per to go forward with the arraignment. So Tumat needs a lawyer for the contempt hearing because it's criminal. Civil stuff, you can just represent yourself and say your side of the story. So they agree that, he was served. The court, there's a request to continue the hearing filed on September 26th, at which time there was a time waiver. And I understand that the civil harassment restraining order hearing is scheduled for 8:30 in this department on December 5th. So I'm going to continue today's matter on the arraignment to December 5th. So now the court is like, all right, cool. Let's push everything to December 5th. We'll have the contempt and we'll have the restraining order hearing. The restraining order is in full effect, but I'm going to deem that Tumat was served on behalf of his counsel. Everything is going to move forward. What happens next? What happens next? Then as far as counsel goes, he has a constitutional right to have counsel present at the hearing on the 5th. Now the court is like, yo, are you representing him today? He's like, look, today only. And I believe he qualifies for the service of a public defender for his indigency purposes. He'll have to fill out the necessary paperwork for all of that. But again, it's a difficult situation because I don't think he knowingly can waive that. Now, look, the other attorney is like, look, man, Your Honor, can I what? Can I be heard quickly? And this is what he says, right? It's a long statement.
Your Honor, you mentioned that the order remains in effect, but apparently it's protection that can't be enforced. Just so the court is aware, on July 6th, the court issued a restraining order against the respondent. Since July 6th, the respondent has continuously and repeatedly violated the restraining order. He's contacted my client directly. He has contacted my client indirectly. He has publicly threatened my client on Twitter to his tens of thousands of followers. He has found out where my client works at her new job. He has put that information online. He has threatened witnesses to this proceeding in writing.
Which has to be Jamesky, right? Like, that's the only one listed.
I have those text messages today, Your Honor, and the issue with guns. Your Honor, he's alleged to have pointed a gun at my client's head, and a picture of that happening was submitted with the application. He was ordered to turn in his weapons, and signed an affidavit attesting to that fact. He has not done so. In fact, since July 6th, he has posted photos of himself with weapons online. I'm asking for this order, to the extent it can be enforced today, to be enforced today.
Mr. Look, his attorney's like, what order? The court is like, the civil, the harassment restraining order. The existing civil harassment restraining order is going to remain in effect. It is in effect until December 5th, and so that order is not being modified in any way. It's still in effect. And he's entitled to, but on the, look, his due process hearing to the court counsel, you can't. The court is like, look, the hearing on the arraignment is continued to the 5th and the order of protection rule remain in effect. Thank you. Like, I don't know why they were thinking like it was not going to be in effect, but it was definitely going to be in effect. So now we have the final day. Now this is a big day, guys, considering Jamesky already got these. That's why it says copy. What happens this day? This is a big day. Early on, you're about to see respondent 2Mad appear via LA Court Connect with his lawyer. She appeared with her lawyer. Everyone, all hands on deck. I'm pronouncing his name correct, like, you know, 2Mad. It's a lot of back and forth. Can you hear me? This, that, and the third. Everyone's trying to get a hold of 2Mad. Now, once they finally get him, hey, yeah, I'm in the courtroom on my laptop. The court, hey, can you hear me? The court, can you hear the court, sir? 2Mad, yes. Can you hear the court? Yes, I can hear you. Can you hear me? Yeah, I can hear you fine. Are you ready to proceed today, sir? 2Mad, yes. The court, you are? All right. We're going to put this on a brief second call while the attorneys go out and talk, and we'll call you definitely before noon this morning. All right, cool. Now look, his lawyer, right? Can the court clarify that he's prepared to proceed in pro per? Can the court confirm that 2Mad's ready to do this without a lawyer? And then counsel and I have talked, and she's prepared to, I believe, they are prepared to drop the contempt. Okay, so now they're like, yeah, we're gonna drop the contempt. The court, okay, sir, are you prepared to proceed in pro per without an attorney? 2Mad, yeah, I don't need an attorney. Court, okay. I mean, like, his fate was already sealed. The contempt hearing was dropped. The restraining order is going to get granted. But what was said in court? Because what Jamesky said, what was said in court, is not exactly true. What was said in court? She talks. Correct. Okay. You're dropping the contempt? Correct. Her attorney responds, yes, Your Honor. The court, all right, thank you. All right. Give the court a couple minutes and we'll call you. We'll have you back on a second call. Respondent, okay, the court, thank you. Thank you. Everyone's like, thank you. But his attorney is like, yo, thank you, Your Honor. May I be excused? Yes, thank you. So now 2Mad is going into this with no lawyer. The court, yeah, go ahead, state your appearance. My name is this. I was here on behalf of 2Mad. Her attorney, hey, I'm here on behalf of the petitioner. It's Goldilocks versus 2Mad. This is the restraining order and hearing. Can you hear me? They go back again. Yeah, I can hear you. Can you hear me? Yes, 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 yes. Everyone stand, raise your right hand. So everyone stands, raise your right hand. Hey, my name is 2Mad.
Thank you, Mr. 2Mad. So, ma'am, the court has before it a request for a civil harassment restraining order filed July 6th of 2023. It has your name and signature on it. Is that correct?
Yes.
Okay. Are the statements and allegations in your petition true and correct?
Yes.
And for purposes of this morning's hearing, would you like the court to accept those statements and allegations as your testimony?
Yes.
The court will briefly summarize your petition, then allow you to add to or correct the court's summary. Allow your attorney to present any other evidence, and then Mr. 2Mad will have a chance to present his side of the case. Do you understand that?
Yes.
You state that you and the respondent are former friends and acquaintances, correct?
Yes.
You met online in 2021, correct?
Yes.
You state that he has S.A.yed you. He's coerced you into dropping neck and intercourse. He's asserted coercive control, that he has firearms, has pulled a gun on you. Is that correct?
Yes.
And what else would you like to tell the court, ma'am?
He has continued to harass me every single day relentlessly for months now. Has made my family fearful because he has sent things to my family's address. He has a history of swatting people.
Can you explain what that is? For the record.
Yes. That is where you make a false 911 call to send a SWAT team to somebody's house or, workplace, wherever they may be, either to scare them or to potentially get them killed.
All right.
He has also leaked my full name online to his massive audience. He has been threatening to leak more of my private info online. He's been tweeting about it, saying he's going to dox me, dox.
Now look, a lawyer would have been helpful, to say he has not threatened to dox her directly. Yeah, I mean, it's semantics, but it is what it is.
DOX, which just means reveal personal information. And he's been threatening my friends, threatening witnesses, trying to blackmail them. A lot. Those are the main points.
All right, thank you. Mr. Too Mad, do you care to respond?
Yeah.
Go ahead, sir.
I met the petitioner on prostitution social media approximately around the end of 2021.
Objection, Your Honor.
I haven't met the petitioner approximately since February 2022. I blocked her from my social media around June 24th, 2023. I haven't called or texted petitioner since the year 2022. I don't own or have any firearms. I don't have any intention to hurt anybody, including the petitioner. I'm a law-abiding person that respects and practices restraining order issued on July 6th, 2023. I would like this court to know that I'm innocent and left alone to live my peaceful life. Thank you, Your Honor.
All right. Counsel, you care to respond or cross-examine?
Your Honor, I'll just say that nothing that Mr. Too Mad just said makes any sense whatsoever, nor is it true. He met my client on Tinder, not a, quote, prostitution site. That's horrendous for him to say. The one thing I will submit on the evidence submitted with our application, as well as the contempt proceeding. I just want you to see this picture, Your Honor, in particular, which shows the respondent pulling a gun on my client. And then, the reason we have this photograph, Your Honor, is because he took it himself through his Ring camera and then posted it on his Twitter account to his tens of thousands of followers.
Hundreds
of thousands of followers. Excuse me, laughing and taunting her. So I'll submit this into evidence in addition to what's already with the application.
Okay, hand that to my deputy. Counsel, sir, I've been handed a photograph of a Ring camera. It appears to be a hand sticking out with a handgun. It says, the caption above it says, to, T-wo, quote, meaning quotation marks. Literally driving, it's like a cell phone, and then, closed quote, mad at 2, T-W-O-M-A-D, mad, July 4th. You've seen this before, sir.
He's like, is it supposed to be visible on a court? It wasn't attached to the petition? I think I know. Her lawyer chimes in. It was attached to the petition. The court is looking for it right now on the petition. This would be the respondent. I just don't see it like on A. It's exhibit C. It would be on page 32 of 34.
Yes. So I don't have or own firearms.
You don't have or own firearms?
Yeah.
So the social media excerpts that she attached to the petition, those aren't you posting pictures of weapons and…
I don't own or have any firearms.
Okay.
If that is the position he's going to take, I'd also like to give you another screenshot from the video he posted online where he goes outside onto his balcony and fires his gun into the air multiple times, and posts that video on Twitter, and I have a screenshot of that video as well, Your Honor.
Is that true, Mr. Too Mad?
The thing is that video is completely edited. It's the muzzle flaring, the sound of the gun going off is edited. It's for YouTube. I'm a YouTuber. It was also recorded quite a long time ago in Las Vegas. There's a couple witnesses to it, but I don't own or have any firearms.
All right.
The thing is, that video is completely edited, which I said it. I caught it when I downloaded it. I slowed it down like the shit's edited. The muzzle flaring, the sound of the firearm going off, it's edited. It's for YouTube. I'm a YouTuber. It's also recorded quite a long time ago in Las Vegas. There's a couple of witnesses to it, but I don't own or have any firearms. The court. All right. Your Honor, I think we should remind him that he is under oath. I think he's aware that he's under oath for the rest of the exhibits, or attached to her petitioner. The email, text message shots, and some are maybe not the most tasteful comments, sir. Responded, yeah, I don't really have anything to say. All right. Is there anything else, Mr. Too Mad, that you want to tell the court? No. All right. Anything else from you, counsel? No, Your Honor. All right. Well, the court finds that the petitioner credible. He finds that she met the burden of proof by clear and convincing evidence. The court will issue a restraining order for 3 years. I mean, the rest is history. It's all in a restraining order. But what you need to take away, no mention of firearms at all. by the judge. Maybe the judge is in belief that he doesn't own any, and all ROs require you to submit your firearms. And this was communicated to me on the 19th of 2024. But I did like the fact that the biggest takeaway is this right here. The part where he said, hey, look, I don't own any firearms. And that video you saw is just me editing. It's muzzle flare and fire, you know, a gun going off. But what do you think? This was completely omitted from Jamesky's manifesto, as well as 2Mad pretty much doubling down that he met her on what he believes to be a prostitution website. And, you know, I don't think this is a ChatGPT. Maybe it is, maybe it's not, but the judge didn't shut him down at all. So when Jamesky's talking like, oh, well, you know, he got shut down and his lawyer had to stop him from talking and making him plead the fifth. All that you saw in this, I told you, lies by omission, complete exaggerations, anything to villainize 2Mad. Now you have a complete clear picture of everything that was said in court. All the court documents can be found on my channel on this video or another. But what do you think? Now, 2Mad was definitely not innocent of harassment, but Jamesky, if he omitted stuff like this, what else is he omitting to further bolster his case? Let me know what you think of the video, and I'll see you in the next one. Peace.